my lords.
Yes.
As I said at the beginning of my submissions, I was going to cover 6 issues. The first
Yes.
of which was looking at the high hurdle that my lords will see from the various authorities, which I dealt with when I looked at charter. So I'm now going to look at the policy in general and then policy-specific wordings.
I'm sorry, I didn't hear you.
I'm going to look at the policy in general and then specific wordings in the policy.
Right.
So my issues 2 and 3.
Yes.
I identified at the beginning. So with respect to the policy in general, as I mentioned, I think earlier, and as is evident from the judge's judgment, this is not an off-the-shelf policy, and this is obviously important when one considers ground 3, which is the FCA point, if I can put it that way. And indeed, it was a policy that was the product of negotiation between expert and advisors, and indeed had a bespoke nature to it. And the bespoke nature had 2 elements, which we can see from the chronology, which is in the core bundle, bundle A. And this is behind tab 3, page 24. So it's a short chronology of the relevant events. We see, as I noted earlier, you have the SPA actually agreed on the 19th of November 2019, and then there follows over the page at page 25 a short summary of how this policy evolved. And as you can see, the initial draft was sent over on the 20th of November, and then a further second draft was on the 28th of November, which was accompanied by a note in the margin. And with respect to the Appendix C, we can see that there is a choice to remove spread brackets.
Was this material which the judge said was not admissible?
It is material that he said was not admissible with respect to what was said in these meetings, but as a matter of the structure of what was done, i.e. the fact that this was negotiated between the parties.
Well, that I can understand.
And the fact that the exclusion came in at a later stage within negotiations is all I'm relying on here, bringing to the attention of the court. What I won't be doing and haven't done is brought to the attention of the court the various discussions, WhatsApps and such like, which were ruled inadmissible.
Yes.
So that's the first feature of this policy. The second is the nature of the loss, and we've touched on this previously, which is what is the loss, what is the quantified matter to be indemnified under the policy, which is obviously referable to the general rules and general law on SPAs and breach of warranty. So if I could take you, my lords, to the bundle of authorities behind tab 4. This starts at page 68, and it's the case of the Hutt Group. Here we have at page 99, paragraph 179, a brief summary of the appropriate principles when it comes to valuation in these sorts of cases. Now, this will be familiar territory to the court, so if I could just ask my lords to read 179, 180, and then 184, then I'll make my point. So what this articulates is the well-known principle of warranty true, warranty false, i.e. one's looking at the diminution in value to the business or the company or the shares after acquisition, once it's become apparent there's been a breach of warranty. The reason why I mentioned that here, before we look at the policy generally, it is of course that when one's seeking to identify what's indemnified, it's not indemnification of the breach in and of itself, it's indemnification of the loss of value as a result of the breach. So that's why the loss is expressed in this way, because what that allows one to do is to identify how much the value has dropped as a result of the breach of contract. The reason why that's relevant here is also because this isn't a liability policy. So it's not referable to insuring the insured against the risk of a liability. It's simply that the insured has, for example, shares that are worth less money than they should have been. So when we come to look at, for example, Appendix C, which is referable to the clauses in the warranties, what's not insured is the warranties themselves. What is insured is the risk that the company is worth less than it was promised at the time of sale under the SPA. And that's why we have a calculation of quantum in the fashion we see there summarised in the Hutt Group case. Moving, if I can, to the policy itself, and so that's in Bundle B, tab 2190. So as a preliminary point, our case is one has to look at the policy in the round, reading it back, front to back, back to front. Doesn't make a material difference to the iterative process we go through here. And indeed, that shouldn't elevate, for example, going back to front, Appendix C to anything more significant than being part of the policy. What we see is the schedule at page 1, and then if we move on to the insuring clause, which is familiar territory by now, at 3.1 at page 200. So we see that, first of all, subject to the terms and conditions of this policy. So again, that's not an anodyne phrase, it's a clear indication to the reasonable policyholder, in this case advised by expert advisors, that you need to understand the totality of the policy and everything that's been agreed before you can say, I have a claim or I'm entitled to an indemnity. But if you are seeking to make a claim, then the underwriters shall, in excess of the retention and an aggregate for the policy period up to the limit of liability, indemnify the insured for and pay on the insured or pay on the insured's behalf any loss covered by this policy. Now, before we look at the word loss there, a point was made of criticism of the judge's judgment as to the weight that he placed on the phrase or pay on the insured's behalf, which indeed it says here. We would say that that is referable to a particular part of the calculation of loss, which is at 4.1.4 at the bottom, where we can see that any costs, fees or expenses, including disbursements incurred by or on behalf of the insured or incurred by the target group in relation to any counterclaim or third-party demand in connection with any subrogation claim pursued by the underwriters. So you can see here that there is a circumstance within the definition of loss generally, not the part we're concerned with today, where an underwriter might have an obligation to directly indemnify or pay on the insured's behalf certain monies.
Wouldn't the same be true of defence costs?
Yes, it would. Yes, it would. But the point that we're concerned with here is, of course, loss is traditionally understood as summarised in the Hutt Group case, and as defined at 4.1.1. So the amount of monies which the insured is legally or contractually entitled to claim against the sellers pursuant to acquisition agreement for a breach, or would be entitled to claim in respect of such breach if limitation provisions were disregarded. So the loss as defined here in this case is the diminution in value of the shares of the acquired or target company. Now, in the context of ABC liabilities, as we will see as defined in a minute, bribery and corruption can affect the company in many different ways. It, of course, could create liabilities for the company directly. It could create liabilities for the company indirectly by vicarious liability, or agents or other parts of the group. It could affect the company's value by the person who's corrupt, stealing value from the company, assets, IP, goodwill. It could equally affect the company if there's an alleged act of bribery or corruption, either because it directly affects the goodwill value in the company, or just affects the company's reputation, or indeed its relationships with either its customers or its suppliers. So there are many different ways in which bribery and corruption might impact on any calculation of loss. So when one understands the term loss, it is through that lens. Equally, when one understands what is covered, one will have a look at the Appendix C. But before I do that, I want to just focus on the exclusions, which are at exclusion 5.201. So here we have effectively two main elements of exclusions, 5.1, which is called known issues, and then 5.2, which are the particular exclusions. Now, known issues, of course, are restricted to actual knowledge of particular individuals within the target company. With particular individuals that are identified in the policy. And what is being said by the underwriters is, if you know about something, or it's been disclosed to you under 5.1.2, then any loss you claim will be excluded. And that can, of course, cut across knowing specific warranties have in fact been breached or may well be breached because that's been disclosed. So it may be that there is a warranty that says we don't have a case, any liabilities, but actually disclosed is an ongoing claim. So that wouldn't be covered in this particular case. So there's an immediate impact on the degree to which insured warranties may or may not in fact lead to a claim under the policy. 5.2, we have a long list of exclusions. Now, obviously we're focusing on 5.2.115, the ABC liability, but it's worth, I suggest, considering this as a whole and bearing these points perhaps in mind when we look at the interface with Appendix C. So the first is that these are clearly wide-ranging exclusions, and it's apparent to the reasonable reader at the very beginning that the underwriters shall not be liable to pay any loss to the extent it arises out of any of these matters. So it's not directly referable to what's in the cover sheet. It's talking about what loss and the causative relationship between the subject matter in the exclusions and the loss that's claimed in the claiming process post-inception under the policy. 2 points arise here. The first is the nature of these labels, and the point is that they are simply a label. The fact that they use certain language does not in and of itself tell the reader what is at issue. There's a need to look at this and to take the question of any leakage, for example. Plainly, that doesn't have the normal and ordinary meaning of the word. It's a technical phrase, and it is a phrase that is subsequently defined within the policy. Although we'll see that doesn't really help us.
I think that just tells you look at the acquisition agreement.
It does. And so if we look at B95, we'll see how that's put. So as my learned friend rightly said, leakage is a phrase used within the context of what's called a locked box mechanism. And that's creating a particular period where there might be a change in value to the company. So we see here at 1.1, each seller severally and independently warrants and undertakes to the buyer that during the locked box period, no leakage has occurred other than any permitted leakage. And then we see a definition there of leakage. And there are 2 points to be made here. The first is the exclusion 5.2 excludes any cover for leakage here. And yet we see here there's a warranty that expressly deals with that and allows under the SPA a claim if there is leakage, unless permitted.
Sorry, there's a warranty under the SPA that there's been no leakage.
Yes, unless it is any permitted leakage. That's 1.1 at 95.
Right, is that one of the covered? Is that an insured obligation as defined in the policy?
I will have to come back on that particular point in a minute. But the short point is that it's an exclusion for leakage. And the leakage is defined in a very complicated fashion at 1.2. So the label is very snappy, but doesn't tell the whole picture, but it tells the whole story at all. So that's an example of how the parties have chosen to structure the policy in this fashion. The second point on the long list of exclusions, if we go back to 202 in the bundle, is a point that's taken against me, which is we see here that the word liability is used on many occasions throughout the exclusions, and we can see that at 5.2.6, secondary tax liabilities, 5.2.11, dilapidation liability, and 5.2.12, and also at 5.2.14. Now, if we were to look at the secondary tax liability and for it as an example as defined, which is at 197, we can see that this definition the parties have chosen has none of the similar language, the ABC liability, expressly and is deliberately chosen simply to mean any tax liability. Nothing about alleged or actual is liability, which makes sense, because a tax liability for a target company would be explicable as something that a company has to pay to the exchequer.
Yeah. If you look at 5.2.11, talks about a dilapidation liability, and then look at the definition of that on page 193, it doesn't use the word liability at all.
That was
a defect, shortfall, right. Deficiency.
Yep. But what is going on with the language used by the parties are deliberate choices. So just because it says liability in the label doesn't mean that it's solely relating to a liability. It could be expressly a liability, as we see with the tax. It could be a liability or actual or alleged breach. Or it could be something that doesn't describe a liability at all within the definition. So the message one I suggest a reasonable reader will get from these sections is that there are deliberate crafted decisions made by the parties as to what losses won't be covered, as distinct from what are the insured obligations under the SPA. And that's key because you have the causative causation language that arises out of there. So it's not all losses that have any old connection with any of these particular exclusions. They have to arise out of these exclusions. There has to be a causal connection. So this is, as I've already mentioned, a series of exclusions crafted at length and negotiated at length by competent commercial parties. When one then looks at the specific ABC liability exclusion, of course, it is defined in the definitions that my lords have been taken to already, which are at page 192. So we have here the ABC liability is defined. We say it works on its own face, putting aside the contradiction for the minute, and we say that it's clear what types of anti-bribery and corruption laws are in play. So we can see there, for example, corruption, anti-money laundering, counter-terrorist financing. So some care again to identify the scope of this liability. And then when we look at the ABC liability itself, it's any liability or actual or alleged non-compliance. Now, dealing firstly with that phrase, there is a choice to use the word all there. And it's in the context of the broad nature of this exclusion, the use of the words like any or all. And to have a distinction, and a viable distinction, between a liability or an actual or an alleged non-compliance. So I support the judge's analysis that there are three types of categories of matter that are being captured by this exclusion. And his definition, which is put forward, and I endorse within his judgment, which is in Bundle A, tab 5. Paragraph 34 at page 48. So we would accept the way he has put this interpretation, and we would submit that it doesn't do any violence to the language, and certainly not the significant changes that are being advocated for by my learned friend.
So in respect of his 34 Roman 1, whose liability is he talking about?
It's any liability in the context of the loss, and the loss is the valuation of the shares. So
anyone's liability if it amounts both to a breach of warranty and causes a loss.
Precisely. So it's wide-ranging and captures everything. And if you need me to give an example, if you had a company who has a relationship with a third party, or indeed a selling agent perhaps, or a commercial agent, and that third party is in fact committing various corruption or bribery, or various of the money laundering allegations or the anti-terrorist allegations, and that person has been identified with the target company, that can have an impact on the valuation of the company and the valuation of the shares, even though that company in and of itself might not be liable. So if, for example, your commercial agent or a close trading partner is found liable of, say, terrorist charges, that is likely to have an impact, or could have an impact, on the value of the company. Maybe your main customer is in fact doing that.
So you say, do you, that if a company's main customer is accused of corruption and as a result, for instance, stops trading, so the target loses its main customer, how's that going to be a breach of warranty?
If the person knows that if the seller knows that this is sufficient to trigger a warranty breach. So what I'm giving you is an example of how that might affect the value of the company. That is a different question from whether that would be a breach of warranty. So one can see that there's a situation where a liability for a third party might impact and thereby create a loss. But that's a different
How is it
question.
a breach of warranty in the first place?
Well, I say it isn't a breach of warranty. I don't have to say it's a breach of warranty. That's a different question. I'm giving an example of how it might impact on the value of the company in the context of whether there's a loss or not. Obviously, they'd have to demonstrate that there's some sort of breach in the first place. Perhaps there's been a warranty to the effect that trading partners are not committing these sorts of crimes. Or maybe it's should have been recorded within the records. But in a sense, this brings forward a more fundamental point, which is, when dealing with bribery and corruption, there's such a wide nature of bribery and corruption, or anti-terrorist laws, or
I'm wondering if the answer to the question I asked, I'm sorry to interrupt you,
Please.
is because of the definition of associated person in the warranty is so broad.
My lord, if I may just go to paragraph.
So page 74.
Yes. It is potentially that, and the other point that I had also in mind is potentially maybe the breadth of relevant persons as well at 75. And then you see associated persons again at 13D.
Yes, I see, and that does include distributors, contractors or subcontractors.
Exactly.
Why would it be dealt with by reference to liability rather than actual or alleged non-compliance?
Because if I could take you back to the learned judge's approach to defining this, as opposed to the particular point my Lord Justice Lewison brought up. So to answer your question, my Lord, if we look at para 34 within the judgment, so we got paragraph 34, little Roman 1, and my Lord Justice Lewison was asking, well, whose liability? Saying that there is conceivably a position where a third party's or someone else's liability could impact on the value of the company. In answer to your point, my Lord, at little Roman 2 and little Roman 3, there is an answer to whose alleged non-compliance or whose actual non-compliance, which is defined as the member of the target group, any agent, affiliate, or any third party in respect of those laws. Now, it may be that that is a similarly wide category of people, as my Lord Justice Arnold identified within the body of the warranty. But what this is telling the reader is we know whose alleged non-compliance and actual non-compliance is at issue. So it's a different question from the one that my Lord Justice Lewison asked.
I just don't understand that. Can you try again?
My Lord, would you mind posing the question again?
Well, your case is that the exclusion relates to non-compliance with any member of the party, agent, affiliate, etc. Why is there a reference to liability of some other persons? Why isn't that just dealt with by non-compliance?
So the people who might be liable are anyone who's a third party, but the people whose non-compliance we're concerned about at little Roman 2 and little Roman 3 are identified. The set of people at 2 and 3 may be a smaller set of people than at 1. So they're doing different things.
There seems to be extraordinary contortions to make sense of this.
With respect, my Lord, I don't think it does require any contortion in this way. So if we ask whose liability at 1, we simply say liabilities in general. If we ask about whose non-compliance at 2 and 3, then the answer is any member of the target group, etc.
But the etc. includes other third party.
Any other third party in respect of the anti-bribery and anti-corruption laws. So you'd have to look at the anti-bribery and anti-corruption laws to understand who that third party is, who may be different from liabilities generally. I.e., the liability of a person could be outside the subset of people identified as Roman 2, little Roman 3. But even if you're not with me on that, it doesn't render it nonsensical or irrational or arbitrary, because it still works. And indeed, the parties have agreed that within the context of the clause itself, it works to exclude this claim.
Do I?
Sorry. You go. What I see at the moment is that the label ABC liability, you'd expect, must at least have some linkage to the definition. At the moment, I can't see how one gives any substance to the concept of liability, because it's difficult to see how there could be an exclusion for liability that wouldn't be caught by the exclusion for non-compliance.
Oh, I understand my lord's point. I apologise. The point regarding liability is, I would suggest, and this goes back to the deferred prosecution type points, is a liability is a declaration that you are liable. So, for example, a court order, a judgment, an arbitral award. That is obviously materially different from an alleged non-compliance, which is not proven, or an actual non-compliance, which could still exist without, for example, a court declaring that it does exist. You could still have an actual non-compliance without there being a liability attached to it. They are two different things.
Yes, so when will you ever need a liability? That's the point.
So a liability could have different consequences from simply having a actual non-compliance, because a liability might carry with it, if it's, for example, in the form of a court judgment, an award of costs, an award of interests, and various other penalties, for example, if it was a criminal judgment. I.e., just because I haven't complied with corruption laws might have an impact on the valuation of the business. But if I'm also liable for that non-compliance, then there are different and additional consequences that will impact on the valuation of the business, such as, for example, penalties, interests, or costs, which wouldn't otherwise exist.
But the liability in any of those cases is going to arise out of the matter's non-compliance, isn't it? So it's just, you don't need to have that stage because the loss will have arisen out of non-compliance, whether or not there's an intermediate stage of liability.
So there are 2 points, it seems to me, my lord. First, are liabilities and non-compliances different? And I say they are for the reasons I just said. The point, my lord, I understand this making is there's a surplusage here. So why do we need liability at all? Now, the fact that there's a surplusage or not doesn't mean that it renders the clause incoherent. At worst, it renders the clause flat.
But it's just odd that the surplusage should be the liability aspect when the clause is labelled ABC liability.
Well,
and as we've seen from chart book, we do assume that the label has a meaning that is not arbitrary.
But also the point that I was making when we were going through chart book is just because something looks odd, or may not be the way one would normally draft something, or ideally draft something,
But we're into the detail now, aren't we?
Yes, but the point is, just because it's odd or it's surplus doesn't render it irrational or arbitrary, which I say is a much higher level of criticism of a clause in order to justify the rewriting of the clause. Now, at worst, if one thought that any liability was a subset of actual non-compliance, it's simply surplusage. It still works as a clause. But I think there might be a further point my lord has in mind, which is going back to the labels point, in a sense, which is if we're talking about ABC liability, wouldn't you expect the word liability to be doing something different within the clause? Now, ABC liability in and of itself doesn't tell you what's defined. The parties have chosen to use these words and specifically chosen to cover a wide variety. And if it's belt and braces, so liability might be a subset of actual non-compliance, that doesn't render it incoherent. It just means that they were trying harder or intended to cover every eventuality that they could think of. So if one was to have, for example, a clause that lists out lots of different things, like pollution, contamination in a contamination clause, there might be an argument that there's crossover between what's pollution and what's contamination, but the parties might still use both those words in the exclusion to give it the widest possible opportunity to capture a loss. So the fact that my lord might be concerned that liability isn't doing everything that one might like doesn't render it incoherent or inoperative.
At some point, I don't want to take really your course of the detail, but I'd like to ask you about the context of this policy within the SPA. Can I do that now? I don't want to take you very come back to it.
My lord, if you want to pose the question, I'll see whether
It's a
it's
question.
difficult.
As I understand it, this policy was a precondition of the SPA,
Yes.
and it was a precondition that the buyer provided the policy.
Yes.
And the way it works, as I understand it, is that the buyer must first claim on the policy
Yes.
and can only go after the sellers if they haven't got cover, can't claim under the policy.
I believe so.
And also, under the policy, your clients have no right of recourse against the sellers, except in fraud or...
Yes. Has limited rights to subrogation, yes.
Right. So effectively what's happening is your clients are replacing the sellers prima facie under the warranties, looking first and foremost to your clients, and they haven't got a right of subrogation.
The reason why I would depart from that statement is that there isn't a perfect mapping between the obligations on the SPA and those insured.
In particular, because the insurers are liable even if the sellers aren't liable because of limitations.
There are a variety of additional protections in the SPA for the seller that aren't available to the insurer, such as limitations under the policy.
But to be clear, I think the reason why it's important, contractual matrix, is when one's looking at the competing interests of the parties, and your clients are saying, oh, well, we want to exclude as much of the liability as possible. You're not here just insuring some parts of the warranties. You are prima facie being the party who will pay up under the warranties. So one wouldn't expect the exclusions to be particularly wide, because the whole point of this contractual bargain is that the buyers will look to you, not to the sellers.
Or that we part company there, because actually I would suggest, and now talking about in generality, and then we'll come back to the policy and how this was actually formed. In general, you would actually expect the insurers to be delimiting their risk by using the exclusions, because the position an insurer finds themselves in is very different from the dynamic between buyer and seller. So the buyer and seller, as you will well know, have multiple opportunities to discuss the risks of the company and indeed bespoke warranties and investigate and undertake due diligence. The insurer has none of those opportunities. So that means that the risk, if it was simply written on a sort of carte blanche basis, is much higher for an insurer in those circumstances.
So they charge a high premium.
Charge a high premium, or you can try and
Who
delimit
pays
the
the
risk.
premium?
Sorry?
Who pays the premium?
In this instance, the buyer pays the premium, as I understand it, i.e. it's not the seller, but there are instances where W&I insurance...
Presumably that's factored into the purchase price. So in a sense...
Well, in general, it will be part of the negotiations. I wouldn't like to say that there is a obvious, let's say, £500,000 premium, £500,000 increase on the price.
Yeah.
It's part of the mix, so to speak. So the reason why I say I part company from your analysis then is actually that is a very good reason why an insurer would want to identify broad exclusions. And that's for two reasons. A, the insurer's identified there's a particular risk here.
Yes.
And B, because then the insurer is not part of the process, and this is more acute in this case because it was done after the SPA, the insurer has no opportunity to explore the nature or level of that risk like the buyer does. So the best way of hedging the risk for an insurer's perspective, and I appreciate there are two perspectives to a bargain, the best
There are
way...
three perspectives here because you've got the seller as well.
Um,
It's the seller actually who's the party who's really interested in your cover being wide.
I would agree with you in general, my lord, but not in this case, because of course the SPA is agreed before the insurance is placed. But there
No,
have
but
to
the
be,
seller's got to approve the
got
policy
to approve it,
as a condition precedent.
but the dynamics are, as we've seen, although I can't tell you through the complete amounts of information because it's inadmissible as ruled by the judge, it is that the dialogues post-SPA are between the insurer and the insured, and the buyer does not appear to have been a party to the negotiations as I
Buyer
understand. Sorry, the seller.
Seller, yeah.
So in this case, the reason, looking at it objectively, from the sort of reasonable perspective, an insurer would actually want wider, not narrower exclusions, is because of the nature of the risk that that insurer is taking on.
This is interesting and for my part helpful to understand the context of this particular policy. But at the end of the day, is this any different from any insurance policy? Because it's always in the interests of insurers to have exclusions. It's always in the interests of insured parties to minimise those exclusions. And the trade-off is always the premium.
Yeah.
That's true of any insurance policy, isn't it?
In broad terms, my lord, yes.
Well, it's unusual to have no right of recourse, and also to for the insured for the seller not to be liable if the insurer pays up. I mean, that's a very unusual situation in insurance.
It is an unusual situation in insurance generally, but not in this particular
No,
one.
I can see this market wouldn't make sense otherwise, in a sense.
And that's why, so going back to my Lord Justice Arnold's point, there are actually maybe at least two different mechanisms to achieve a deal. The one is how you define or limit the risk, and the other is the price to be paid. And while I haven't taken you to it yet, the impact solutions case, or just Lord Toulson's speech, is very helpful about how exclusions work, because exclusions aren't necessary exclusions as we would understand them in, say, a sale of goods contract. Exclusions also form part of the mechanism to just identify what the risk being taken on board by the insurer is. So to pick up,
Well,
sorry.
speaking for myself, I'm not being very familiar with that case. I might find it helpful to have a quick look at it if you've got time.
I hope I have. We'll see. If I could take you to that now. Tab 10, so I think that might be in the first bundles. So this is a case dealing with liability insurance for solicitors. And one of the issues was, well, if you've got an exclusion, should one treat it, for example, differently from any other of the clauses that seek to delimit or identify cover, i.e. should the courts be more sceptical, more preferential to an insured? At para 35 of Lord Toulson's judgment, I suggest there's a helpful paragraph which I'll ask you to read, and I'll make my point if I may. So that's page 329. So we see, for example, the conclusion in the last sentence, that one can use an exception as a way of delineating the scope of primary obligations. And that point is made also at para 7 of 323 in the speech of Lord Hodge.
This is where he talks about a contract to paint the house except the garage doors, isn't it?
Yeah.
Just to clarify, in the nature of this policy, it seems to me the key thing about it is that unusually for an insurer, what they're effectively doing is standing in the shoes of the contracting party.
In a sense, yes. Yeah.
In a very real sense, because they are liable and the contracting party is not.
The reason why I said in a sense yes is for two reasons. First, and this is relevant to the way that Appendix C, the cover sheet works as well, is that there isn't a perfect mapping of the liabilities.
No, I entirely accept it's not perfect, but the broad thrust of it is that the insurers take on the liability without recourse, and no recourse from the insurers, but also no right on the part of the buyer to sue the seller.
Yeah.
So in a very
insofar
real
as it's
sense,
covered.
it's almost like, and to that extent, it's almost like an ovation.
The other point that I was going to say is applicable here is, of course, the exclusion 5.1 that we looked at earlier, which is the known risk exclusion. So what isn't being done by this policy is underwriting the commercial decision-making of the buyer. Right? So if there are matters known or disclosed to the buyer, those matters are not insured by the insurer.
Yeah.
So that's another reason why it is materially different. However, you are right, my lord, to say that it is unusual and there is a degree of risk for an insurer, which is leading to a commensurable premium, but also the way that the policy is put together.
Yeah.
So what Appendix, and this is sort of jumping ahead on my points, but just in summary, we've touched on it already, what Appendix C is seeking to do is saying, okay, we're not underwriting the totality of these warranties, but here are ones that are in principle within cover. And then what the exclusions are doing is delimiting the cover further to say, well, we have insured loss that might arise from these breaches unless they arise out of these matters. And that in a nutshell is why I say that they're not contradictory, because they're doing two different things.
And if you're right on the exclusion, then the buyers can sue the sellers for breach warranty.
I'm going to say yes to that, but I know it's not necessarily that straightforward because it will be governed by the policy and also governed by the SPA. But in principle, yes. So dealing with the function of the appendix, as I said, that is identifying the categories. And then when we go back to the policy, if we may go back to the policy, so that's in bundle B. And I was looking at the exclusions, we're at 201. So we were looking at 5.215 and then the definition, within the definitions at 192. And I was obviously seeking to defend and support the analysis of how this works, set out by the judge within his judgment at para 34. The point that I was then going to address is, well, having already identified and submitted that you don't need to change this for it to work, even though there might be surplusage, but that isn't a reason to correct it. one then looks at the way that the appellant seeks to correct it, which is to add the word for. Now, there are 3 points here. On the doctrinal test, is it obvious that that is the solution to the perceived inconsistency or alleged inconsistency? I would say it's not, because it will still have a degree of capture when it comes to those warranties described as cover. It's inevitable because they deal with questions of liability as well. The second is, when one's looking at this naturally, is there a reason to think that something has gone wrong with the language? No, and for the reasons I said, because I say it works. And third, if you were to add for, does this make it any better? So any liability for actual or alleged non-compliance.
Depends what you mean by better.
Does it, does it provide a solution to the alleged problem arising from the interpretation of the policy? And I say it doesn't. It doesn't solve the problem, and it in fact makes a different problem, which is equally undesirable. And that arises from the notion of whether there can be a liability for an alleged non-compliance. I know this is a matter that was debated in earlier submission at lunch. The reason why I say that to the reasonable policyholder would not make sense is because more as a matter of natural language rather than, for example, something I've described as esoteric, like a deferred prosecution agreement. And the natural language is that you can't have a liability for something that's alleged, because by definition, to have the liability, the allegation must be proven. It is no longer alleged within the natural use of language. Now, one might think of situations...
Say liability for an allegation is an oxymoron, I understand that,
Yes.
but what do you say to the point that in the real world you can end up losing money because of an allegation?
Yes, as my lord about to come on to that. So putting aside the deferred prosecution agreements for now and dealing more with my Lord Justice Phillips' point about, well, what about a settlement agreement? So let's say in this case, various allegations were made against my client and I settled. And on the scenario my Lord painted, it's without admission of liability within the body of the agreement. So by definition, that sum of money I end up paying to the other party is not on a liability, it's on a non-admission of liability.
Well, the liability to pay is a liability.
Well, the liability to pay arises out of the contract of settlement, not arising out of any liability arising from the allegation in and of itself. So if we're using an anti-corruption law, and I settle with you, my lord, I'm paying you under the settlement agreement because of making a contract with you. I'm not paying you because I have an actual or alleged breach of the corruption laws. Now, my Lord Justice Arnold's point is, well, stepping back at this, and, you know, in essence, you're making that payment for one reason only, because someone's made an allegation against you. Well, that might be right, but that's not the nature of the liability.
Even if you have a judgment, strictly speaking, your liability to pay doesn't arise because of the non-compliance, it arises because of the judgment. The cause of action has merged into the judgment. So you can say the same for, on that basis, you'd never be covered. It would never be covered for any determined liability, whether by settlement or judgment.
The reason I would differ on that point, my lord, is that the judgment would have the effect of crystallising the liability, and until that judgment, that liability doesn't exist.
Yeah, it would be a liability to pay the judgment, just like it's a liability to pay the contractual settlement sum.
But on the premise,
It's exactly the same position.
I would say there's a material difference between that and the scenario my lord painted, which is, on the scenario, there was a positive non-admission. This is not, I'm not paying you this money because I'm
So
lying.
in other words, it's because it's consensual.
Yes.
It's because it's a voluntary agreement to pay money. You say that's the difference.
That is a material difference, and then the liability to pay that is because of the compromise, not because of, in this case.
What if it's a judgment by consent?
Well, then presumably you'd have a Tomlin order behind it at that point, and the Tomlin order would have a similar set of terms to the ones that my lord has just painted, which is a non-admission of liability.
Well, I think if your answer to this is that a settlement agreement is in some way different, or I think that's dancing on the head of a pin myself.
Well, my lord, I understand your point on that. Sorry, I understand the point you're making on that. I do think, and I submit that it does make a material difference. But in a sense, this demonstrates perhaps some of the difficulty in the debate on this, because rather than dancing on the head of a pin and perhaps being the pedantic lawyers that FCA counsels against, what's the gist of this? The gist of this exclusion is that the insurers have negotiated a delimitation of coverage. The parties have agreed that, like, as it says here, any liability or actual or alleged non-compliance should not be within the cover in this unusual type of insurance policy, as my Lord Justice Phillips identifies.
So I think this is going back to the point you made earlier, that what this tells us is it's intentionally a broad exclusion and it's trying to catch everything.
Exactly. And the point that I was making in response to the dancing on the pin issue is that dancing on the head of the pin and trying to think of all the potential ways in which this clause might fail is perhaps missing the point, which is it's better to look at upholding the bargain that the parties have come to and making it apply as it applies in this
I think
case.
it's the other way around. I think it's you who's looking at the ways that it wouldn't work on Mr. Salzade's.
There is that, but equally that goes to whether it's necessary or even a solution to the problem to add the letter F and make or into for. And it isn't necessary. And if it does,
That's a different point.
but if it does, we enter into the same arena where the same points that are made against me and my client, that somehow this clause doesn't make sense or the judge's interpretation doesn't make sense, are equally good points against the construction that my learned friend contends for.
And that goes to what? To the question whether it's obvious to make that correction.
Yes. Well, it goes to 2 points, whether it's obvious, whether that undermines the clause as stands, is it obviously incoherent or arbitrary? And then secondly, is this solution the obvious solution? And it isn't the obvious solution for the points I've made.
I'm sure it'll be picked up, but I can just see as a large chunk of transcripts being attributed to me when it was in fact you.
I'm sure it will be picked up, my lord. I'm grateful for that.
All right. So
So,
just keep an eye on the time, Mr. Quining. Where do we go from here?
I will. So going from there, we're now going into the spreadsheet and how that works, although I have covered some of those points already. So dealing with the spreadsheet that we find, or the cover sheet, at page 213. Now, the broad point, as is probably abundantly clear from our skeleton argument, is we say that the rubric is the answer to the problem. And of course, at this stage, that's the problem which is identified as stage 2 within my Lord Justice Lewison's sort of analysis, i.e., if there is a contradiction, what's the solution? And we say that's the answer. But before we get to stage 2, there is stage 1, which is there a contradiction? And I hopefully have explained the reason why I say there isn't a contradiction for this reason. So this is, as I said, a summary of what falls potentially into cover. It doesn't entirely map all of the SPA, and then that's subject to the primary terms of the policy, such as the exclusions. And this is identifying the insured obligations, but that's different from the loss that's to be indemnified. So this identifies what parts of the SPA, if breached, might allow a claim, but it doesn't tell us what loss is covered. And that makes sense for two reasons. A, what loss is covered is dictated generally by the other terms of the policy, such as the limit of liability, the deductibles, and all the obligations dealing with what falls in the insurance clause. And secondly, it's subject to the exclusions, including the known risk exclusions and indeed the ABC liability exclusion as well. So there is a distinction here between what these two parts of the documents are doing. This is in principle cover, and then the main body, including the exclusions, tell you if there's actual cover for a particular loss when a claim is made.
Are you going to show us what sort of claims under warranty 13.5 would be covered and not excluded by the exclusion?
Yes.
It would certainly help me if you could show us that there is at least some scope for warranties, losses arising out of those warranties to be covered.
So I'm going to do two things, but I'm going to make a submission before that. First of all, look at what's actually an issue, because it isn't just 13.5. There are warranties at 11 as well. Look at the breadth of those. And then secondly, identify how particularly 13.5 works. But the point I would make before I enter that territory is a little bit like the point I was making about dancing on the head of the pin and the permutations and imaginings of different scenarios. I suggest that what we need to focus on is what's alleged here. It may be in the infinite range of variations of bribery, corruption, anti-terrorism, money laundering, that there might be instances where it isn't captured by the ABC liability exclusion, but is captured by the warranties. I suggest that I don't need to prove a negative, but I have my Lord's point and I will seek to explain.
Well, it would help you if you could.
I understand that.
Because Mr. Salzido's point is, well, if you take the ABC exclusion literally, then there is a complete contradiction between covering clause 13.5 and excluding it. If you can show us that, no, that's not right, there are parts of 13.5 which are covered despite the exclusion of the ABC liability, then that is relevant
The point
to the question of contradiction.
I understand that. The point I was seeking to make was having my Lord Justice Phillips' point in mind, where this, even I would suggest on Mr. Saldizo's case, is not like I insure you for terrorism, but I'm excluding terrorism, i.e. giving with one hand and taking away the other.
I follow that point.
And that's why I made the point that it's far more complex than that, and that in and of itself is not enough to demonstrate a clear contradiction. But if I could take you to the pleadings first. So they're in bundle A, and behind tab 8. These are the amended particulars of claim at page 60. So, first of all, we can see what is alleged to be an issue. So we see at paragraph 25 and 26 at 68, the points made, and I note at 26 that, of course, this originally was put on the alternative basis of there being a rectification to achieve the change of the clause, but that was abandoned following the defence. And as a general comment, what's being done here is more akin to rectification territory than it is for construction by correction by construction, or indeed implied terms. But that's not the way it's put. The warranties at issue are start at page 65, which is a paragraph 18.1 and 18.2. So we can see here that 11 deals with litigation and disputes generally. And as we'll see, this is claimed to have been breached by the alleged actions of the seller. And you can see this is put very widely. And it's agreed that the ABC liabilities exclusion would cover this claim, irrespective of the width of 11.1. So we can see here that there must be instances where there would be legal proceedings, mediation, prosecution for many things affecting the target company other than the matters that are the subject of this claim. So we don't have a full mapping there between the exclusion. The point then arises at 18.2, where you have warranty 13.5 with bribery and corruption. Now here they are quite broadly put, and they deal with a number of different types of issues. So the first is a very wide notion of dealing with anyone performing services on behalf of the company, associated persons who've committed an offence under the Bribery Act or bribery, fraudulent or corrupt acts. And then C, we also have further bribery and inducement. And then D, dealing with investigations, inquiries. So that might well be something different. And then at E, we have a maintenance of the record of all entertainment, hospitality of gifts. Well, that wouldn't be covered by the ABC liability necessarily, because you could see you might have a record that doesn't deal with an actual alleged non-compliance. And then we have just the general catch-all, the sellers, nor so far as the sellers are aware, any party connected with any of the sellers have violated any applicable domestic.
I mean, on the alleged facts of this case, any claim in relation to 13.5C, I think, is agreed to be captured, isn't it? Because it's agreed that if you're right on interpretation, then the whole claim fails.
Yeah. So that's why I'm focusing on the nature of this case being the important one. There is no dispute that the facts of this case and the alleged breaches of these warranties that are set out within these particular claims.
So your point on 13.5C is that it is possible to envisage breaches of that warranty which fall outside the exclusion.
What I'm saying is it's not beyond the bounds of possibility that might be the case. I cannot give you any examples, scenarios where there might be a breach of this warranty, but not a breach or not an activation or triggering of the exclusion. So what I can't say, rule out that there might be points where there are instances that breach the warranty but don't engage the exclusion, but I would agree that in most cases it is likely that the exclusion would bite on these warranties. But
I'm not understanding this. C relates to bribes.
yes,
So how would that escape your exclusion?
I can't think of an example to give you.
I'm sorry, I should have said E. I beg your pardon, that's my fault.
Oh, E.
I understood my lord to be talking about that.
Sorry, it was a slip of the tongue.
But if one's saying, Mr. Quiney, can you give me an example, a scenario whereby something might be described under C as a bribe or inducement leading to a breach of warranty, and is that going to be captured by the ABC liability exclusion? I say in all likelihood it will be captured. But what I can't say is that there aren't any situations that I haven't been able to imagine where it might be the case.
And in any event, you say, as drawn, the exclusion does cover warranty 11, or breaches of warranty 11 which are alleged.
I can say with certainty that there will be, I can imagine instances where warranty 11 might be breached but wouldn't be captured by ABC liability.
Yes.
I.e. that's an easier question to answer from me to you, my lord, on this issue. But the reason I bring you to these is I say it's materially different from the example given earlier, which is I insure terrorism and I then exclude terrorism. The answer isn't as simple as that. It's not as black and white. And it's also materially different because of the points I made earlier about how the Appendix C works, which is not meant to say in all instances, you're going to get cover under 13.5. It has to be subject to the exclusions, and we'll come on to that if I may now, which is the second part of my lord's analysis, which is, if there is a contradiction, how do we resolve it? So, my lord, if I could take you to...
Can I just, before we leave that, I haven't got these at my fingertips, but I'd be absolutely amazed if regulations relating to anti-bribery, anti-corruption, anti-money laundering, etc., don't require companies to maintain a record of entertainment, hospitality and gifts. I'm just trying to look it up now.
My lord, do you mind if I press
If you're
on?
going to say that there isn't an obligation under those regulations to keep such records, I'd like to know it.
My lord, following the point being raised by Lord Justice Arnold, we did have a look at lunchtime, and it probably is better for me to interrupt than to say this in reply, because my learned friend won't have any chance to deal with it. But essentially, it looks as if the reason that that particular warranty is included must be because Bribery Act 2010, Section 7, provides a defence for a company to show that it had adequate procedures in place to prevent persons associated with it from undertaking such conduct, i.e. the criminal conduct. And then the Secretary of State is required by Section 9 to publish guidance on what procedures should be. And the guidance, which is a rather thicker document, includes keeping records. So it comes in by that somewhat convoluted route. So the reason it's important to keep records is because that may provide you with a defence if one of these is alleged. So, my lord, I apologise for the fact that we've only raised that now.
Well, the procedures generally are covered by 13.5b, and then the particular record is 13.5e.
Yes.
So
But that's how
there is a warranty already that the company has procedures in line with guidance.
Yeah. And it happens that that does include records. So that's our understanding of why this in practice may arise.
I'm grateful. So if I could take my lords to B213, which is the Appendix C cover spreadsheet.
But just pursuing that point,
So-
it does seem to create the possibility that there could be a breach of the warranty under 3.5e, because that's all about, as Mr. Salzada helpfully points out, whether the company has a defence. And so there may be some difference there between the scope of the warranty and the scope of the exclusion.
My lord, we would say that and accept that point. I think the point I was trying to make fairly to Mr. Salcedo is obviously there are some of these warranties, other than that, which I cannot give you a concrete example, would not also trigger the ABC exclusion. But certainly that warranty that my Lord Justice Arnold identifies is an example of where there isn't a mapping. And that's why I say it isn't as simple as I insure terrorism and then I exclude terrorism. It's more complex than that for the reader. Equally, it demonstrates why Appendix C is doing something different from the exclusions and is intended to do something different for the reasons I've said. But equally, even if it is difficult to identify concrete examples as to where the warranty might be breached but the exclusion isn't triggered, is not a good enough reason to rewrite the clause. It doesn't render this clause incoherent or arbitrary. All that can really be said of it is it renders it a bad deal for this insured at this time and a good deal, as it turns out, for the insurer at this time in this case. So the inherent fact that there might be a perceived difficulty in identifying where the exclusion doesn't cover is not enough to get over the high hurdle, because there's an alleged contradiction, to rewrite the exclusion which was negotiated and agreed.
Yeah.
So, but if you're not with me on that, then the two next levels of the analysis come in. Does the contract tell us what to do? And so thirdly, if it doesn't, can we still reach a view? On this, as I said at the beginning, we do say the rubric is the end of the matter. To the reasonable reader, when it says notwithstanding that a particular insured obligation is marked as cover, that means the reader goes, oh, okay, I cannot be sure that just because it says covered, it will inevitably pay out. So what do I do then, says the reader? I read on, I see certain loss arising from a breach of such insured obligation may be excluded from cover pursuant to clause 5 of the policy. So I'm being told as the reader that even though it says covered, it may still be excluded. And then in particular in this case, where we're dealing with bespoke special clause as I describe it, negotiated by the parties, that will trump what is said in this spreadsheet. On the question of what certain loss might mean, notwithstanding those submissions that I've made, it's said that certain tells the reader that actually it might only be part of the loss. Well, what part? It could be 90%, 99%. It doesn't really avail the appellant here if that's what certain means, because it still means that in a given case, when it says covered, it isn't covered. It's not even partially covered. You only get part of your loss. But I say that certain can't possibly mean that as a matter of ordinary speech here. Certain means identifiable, an identifiable loss, and that's in the context of a claim having been made. Certain does not mean part of a loss. If the writer or draftsman wanted to denote part of a loss, it would have said part of a loss. Equally in clause 5, if the exclusions were meant to have a piecemeal approach, maybe they only exclude a bit of the loss or whatever, it would say. And third, even if certain means part, it becomes unworkable. Because which part? It doesn't tell the reader anything if that's what it's intended to mean. But I say it isn't intended to mean that. It means an identified loss, i.e. something you're certain of. So we say that that is simply at the end of the argument for the appellant on the question of what does the contract do? It tells you the exclusions rule over this spreadsheet. So if I can move on to the third layer of the analysis, adopting my Lord Justice Lewison's 3 steps. If you're not with me as to the effect of the rubric, well, how does one resolve the contradiction? There are 2 tools one can use. The first is asking whether we need to rewrite the policy at all. And the second is whether we can actually identify a hierarchy within the policy that allows us to work out which one trumps which, what effect they have.
Well, if you can identify a hierarchy within the policy, that's the policy telling you what to do, isn't it?
It's slightly different, I may say. So I'll take you to Mr. Justice Foxton's judgment.
It's a different way of telling you what to do.
Yeah. It's a less express way. I'm pointing to this as it's expressly telling you what to do. And then there are other tools as to what the courts might use to try and divine what the parties intended and whether there's a hierarchy. And it's that second point that I'm now going to move on to.
Can I just stop? Your submission that phrase in Appendix C tells you what to do. As I understand it, the spreadsheet is only really given effect by virtue of the substantive clauses of the policy.
Yeah.
In particular, the definitions of excluded insured obligations and insured signing obligations. Refers to the cover spreadsheet. So those are the operative provisions, and then you have which sets out what the cover is, and then you have clause 5.1 sets out exclusions of the underwriter's liability to pay the loss where there's a breach.
Yeah.
that seems to be absolutely straightforward and entirely to be expected. And I can't see how that sentence in Appendix C adds to that. It just simply says what is entirely axiomatic, that the cover is set out in the insuring clauses, which incorporate the cover sheet, and then you have exclusions in relation to loss. So how does the fact that that wording is there, which seems to me to be completely trite, how does that provide you with the clear
So there are
guideline you want?
There are 2 points, if I may make. The first is dealing head on with the question you raise, my lord, and then having a look at how it's treated within the definition of loss as well and the definition of breach. On the first of those, I'm appealing to this rubric in the context that it is decided that there is a contradiction, i.e. the point that my lord's making is that what would otherwise appear trite, i.e. exclusions, exclude losses, is actually not the case in this because the exclusion appears to exclude something that's identified as covered. So on that premise, if the court's not with me that that's what's going on, then we have to see whether the policy tells...
I see that point, but the problem with that argument is that that wording in Appendix C is part of the contradiction then.
I would counsel my lord against that.
It's not an answer to the contradiction, it is the contradiction.
No, my lord, I would suggest that we're not posing the right question. If the fundamental question is what did the parties intend here? And we've got to the point where we have decided that the language, so the interaction between the language of the exclusion and the language of the cover sheet represents a contradiction. Do the parties intend one or the other to be paramount? And the answer is the parties do intend the exclusions to overrule what's said within the spreadsheet.
Yes, but the contradiction is because what purports to be an exclusion on your construction is actually a denial of cover. So the wording in the spreadsheet that you rely upon is part of that contradiction.
First of all, I would dispute the suggestion that it's a denial of cover. And of course, my lord, you've heard...
Sorry, it's the wrong phrase, I appreciate that that's not denial of cover.
Well, if we're being sort of frank about it, the effect of the exclusion is you don't get an indemnity, and that is the effect here. And my lord's point, as I understand it, or certainly the appeal is put against my client, is that when you read the word covered, you expect it to be covered. That's the basis of the contradiction. You've heard my points as to why there isn't a contradiction.
Forgive me, no, you don't. You expect this to be covered, but there could be an exclusion of loss.
Yes.
And that's entirely understood conventionally and within the rubric.
But if you're, my lord, if one is asking the question, how do you resolve the perceived conflict between it saying covered in the spreadsheet and excluded in clause 5? The reason I say this is an answer, and more than simply a trite statement of the obvious, perhaps, is the way that it is put. It says insured obligation marked as covered. So not then, it may still be excluded.
But it's not. This is in no way addressing a contradiction, is it? This is addressing the standard way that the policy would be read. It's not saying if there's a conflict between this provision and the exclusion prevails.
If the premise of the conflict is the fact that it says covered in the spreadsheet and that contradicts the exclusion because it's said that the exclusion wipes out that, the reason why I say this rubric does more than simply state trite law is because it expressly relates to the use of the word covered within the spreadsheet and says if you've got the word covered, it may still be excluded. So don't treat the word covered as telling you you're going to get a payout.
You can't read it like that, can you? Because it's certain loss arising from breach of insured obligation, and that's the cover. So when it refers to excluded from cover, it's not talking about cover in the strict sense. It's talking about whether or not the policy will respond to that loss.
My lord, there are 2 points there. The first is that, of course, the exclusion is referable to the loss, not to the insured obligation. And what's said here is if an insured obligation is marked as covered, then the loss arising from that otherwise covered breach may still be excluded from cover, pursuant to clause 5. And that is the point in response to your questions, I hope, my lord.
Thank you very much.
Right, you were going on to hierarchy of clauses.
I was, yes. So, my lord, if I could just quickly take you to the authorities bundle, and if we could go to tab 17, please.
Bear in mind, Mr. Salzedo needs time to reply.
My lord, I'm acutely aware of that. So the short point is that Mr. Justice Foxton grapples with a similar issue involving jurisdiction clauses, as my learned friend's already taken me to.
Yeah.
And at 579, para 84 through to 87, if I could ask my lords just to read that.
Yeah.
So, my lords, what Mr. Justice Foxton gives, based on authority, is some pointers which will obviously be familiar to the court as to how to deal with the jigsaw problem, as he describes it. And so, looking at the way that the policy is drafted in the hierarchy of terms there, and whether or not, as I would describe them, the exclusion is a special term, a bespoke term, negotiated term, specifically agreed by the parties. And I would say it is. And when looking at that and trying to work out which is more important to the parties, and which should be given primacy, I suggest that the ABC exclusion would fulfil the tests identified by Mr. Justice Foxton. And so if one has to resolve a perceived contradiction, then the better contradiction is to uphold the bargain that is encapsulated within the ABC liability. So that's another example, I say, of where the policy is helping us. Dealing now finally with the third tier of analysis. What do we do if we can't resolve it? Well, the first point is there are a number of options as canvassed in submissions earlier today. The first is, and this is where ground 3 comes in as well. The first is deleting ABC liability completely. That is an option. And I say that is because I submit that the FCA ruling does not create some new principle. It's simply, again, coming back to try to identify what the parties intended. And if the court concludes the parties intended no form of exclusion for ABC liability, or in the case of FCA, no form of pandemic exclusion when there's a disease extension under the policy, then that is a route that I would counsel in the most extreme circumstances. And certainly in this case, it cannot be said that there was no intention by the parties that ABC liability of some description should be excluded. The second option is the option counselled by my learned friend, which is to seek to, I would say, rewrite the ABC exclusion. And I would say that that is not a preferable option, because it works as is. It represents the bargain as struck. And third, picking up the points by Lord Justice Phillips discussed earlier in these submissions, that is consistent with the nature of the risk and the high risk an insurer on a warranty and indemnity policy is taking. It is an unusual policy.
But
I'm
not sure I quite understand this. You're only getting to this stage if the clause doesn't work as it is, and the contract doesn't tell you how to resolve the inconsistency. So you can't really rely on the fact that it works as it is, because we've passed that stage. It doesn't work.
But it gets to the point, which is, why does this work any better?
That's
what I'm
different.
talking
Right,
about.
that's a different point.
And I'm using what's written as a sort of mirror to review the proposed rewriting in. Does this rewriting do anything better or improve in the light of what we know about the deal as struck? And I say it doesn't, because it simply means that it's a narrower clause. It doesn't deal with the totality of the contradiction either, because it still covers and is likely to cover the majority of the warranties that are identified at clause 13. So it's not the obvious solution, is a short point, the rewriting my learned friend suggests. Another option is to review the way in which Appendix C works. And the easiest option would be, if this is in fact at this stage in the analysis what the parties are identified to have come to effectively correct by construction what it says at page 224. And when it says it, you don't need to do anything with clause 11, because they may be covered, it may not be. The contradiction is put strongly on those. But on 13.5, rather than saying covered, you might change it to excluded, to reflect the exclusion. If it is truly said that there is a contradiction as a result of this agreed, negotiated, bespoke exclusion, then it is better to identify these clauses 13.5 as indeed excluded. And indeed, that might have been a neater solution had it been done. But it isn't a necessary solution, which is why I say I succeed on points 1, 2, before we get to point 3.
Would you accept that it's less likely that we've got 8 errors on page 224 than 1 error on whichever page the ABC liability is?
Statistically, I would accept that.
Yes.
As a matter of principle, I think I might actually echo my own friend's point on this to some degree, which is the word error, typographical error, for example, suggests that there has been a failure to encapsulate within the agreement what was actually otherwise agreed between the parties, like a slip of the pen. And I think I suggest we're in a different arena from that. It's making the contract work. So neither my learned friend nor I have to sort of point to this is an error, as a typographical error. Once we get to stage 3, we're just trying to understand, can we make the contract work if we perceive there's a contradiction? And so when it comes to that question, the fact that there are 8 things that need to be changed on page 24, as opposed to 1 letter that needs to be changed vis-a-vis the exclusion, I would say it is not a material point.
Well, as Lord Hoffman said, the quantity of red ink involved is not determinative.
Exactly. Which is why I would say that the obvious and easiest solution is...
And does that feed back into the previous point you made, namely that you say that even on Mr. Saldado's case, the contradictions are not removed?
Yes.
All it does is reduce the scope of the contradiction.
And indeed, not that we've got to this point yet, but issue 3 was about, well, what happens if the court had, His Honour Judge Pelling, had accepted Mr. Saldado's construction, made the change, would it still have captured the allegations. And as we know, the judge declined to deal with that. But the short point being, our position is that it probably would. So does this solution put forward by the appellant provide an elegant solution to an alleged contradiction? I say it doesn't. An elegant solution to uphold the bargain, as demonstrated by the existence of the exclusion, is to put excluded in here rather than covered at page 224, if we have to get to that point.
Yeah.
My lords, may I just check my notes?
That's all you want to say about the respondent's notice, is it?
No. Unfortunately, I'm going to be 5 minutes or so on that.
Right.
I was just checking my notes as to whether I had any more points on the substantive appeal.
Yeah.
And I don't. The only point that I would make is, of course, ground 3 exists. It hasn't been pursued at great length, but the points we make in the respondent skeleton are there. And it certainly doesn't create some new principle. It's more an articulation of the general principle, which is what would the reasonable policyholder believe. And I referred to Brian Leighton garages, which is Mr. Lord Justice Popperwell saying, well, of course, the reasonable policyholder is not someone who's ignorant of principle, misunderstands insurance law, or indeed is not without the assistance of a broker, or in this case, in fact, brokers and insurers. So it only gets you so far, and certainly it shouldn't get to the point of wiping out an exclusion in the fashion suggested. So the respondent's notice. This, unfortunately, is a point where I do need to go into private, because I am going to refer you to the confidential schedule.
All right.
So I don't know what the practical solutions regarding the live streaming.
Do you have to read out?
No. I'm happy to take you to it and make the points in a
Yes. Well, as long as you don't
confidential
read it
fashion.
out, then it shouldn't affect the live stream.
I'm grateful. So there are essentially 2 points. The first is dealing with the alternative construction advocated for by the appellant and how that interfaces with the way the claim is put.
So we are now working on the assumption that the exclusion has the correction suggested by
Precisely.
Mr. Salzizo, so it's limited to liability for.
Yes, exactly. And the reason I can say that on issue 3 is, of course, the parties were agreed that if the judge adopted the insurer's perspective, it didn't need to deal with issue 3 because it obviously covered what was being claimed.
Right.
So the first point is looking at how the claim is put, and the second point is how the preliminary issue is framed, and thereby whether or not there is any safe conclusion that could be reached on issue 3 in the alternative construction. So dealing with the way the claim is put, first of all, if I could take you to the particulars of claim, which are in bundle A. And they're behind tab 8 at 60. Now, the alleged breaches are put forward at page 70, para 34. My name is Brent. And these breaches aren't particularised in any detail in this document, and as we can see from the last sentence, we need to find those in the confidential schedule, which we'll come to in a minute. So this doesn't tell us much about what is the alleged grounds for the breaches. The confidential schedule is obviously in bundle C. And that's behind tab 1. And if I could take you to page 7, paragraph 7. And if I could ask my lords to read through 7.1 through to the end of 7.6.
If the ABC exclusion is limited as Mr. Salzido says it should be, on first readings looks like quite a mixed bag. Some of these would be caught, and some wouldn't. On the face of it, it looks as though what's alleged in paragraph 7.1, 7.5 would be caught by the exclusion. 7.2 might or might not be. 7.3 and 7.4 and 7.6 would appear not to be. Is there a meaningful answer that we can give to this question?
There are essentially two issues here.
Yeah.
The first on this particular point is, my lord, I would agree, it is a mixed bag, but there are clearly, on the face of the pleadings, matters that fall within to the scope of even the interpretation advocated by the appellant. And so if we were to look at the Schedule 1 to the order setting out the preliminary issues, this is B256. So that is the preliminary issue that was framed by the appellant, ordered by the judge, and posed by my client. What is being said in this appeal is, if you're with Mr. Salzido, then you should, he says, declare that clause 5.215 doesn't exclude the alleged breaches. And my simple point is that would be a very difficult decision to resolve on the terms of the issue as put in the absence of evidence, because that requires evidence to understand what the nature of these breaches are. The second point, which is an evidential point, is if it is to proceed to have for issue 3 to be determined, then what's missing, and the opportunity that wasn't taken up by the respondent, is any evidence that assists the court either below or indeed here to resolve this issue in the fashion that it's invited to be resolved in.
So, just trying to see where we're going with that. We assume that we agree with Mr. Salzido that the exclusion should be changed in the way that he suggests it should. So then that means that issue 3, so to speak, arises.
Yes.
But if I've understood what you are saying, you're saying, well, we can't answer it in the abstract just like that. So how does that differ from what the judge said it didn't arise, but you're effectively asking us to say, well, we can't answer it at this stage.
There are 2 points. You can't answer it at this stage, but the reason you can't answer it, I suggest, is because there's no evidence adduced to answer it.
I mean, having construed the ABC exclusion, it may be open to your clients, I'm guessing, to apply for summary judgment or strike out parts of the claim. Maybe, I don't know.
So,
But, I mean,
your point is that effectively Mr. Salzedo failed to present evidence necessary to win on the third preliminary issue.
yes,
So he should effectively lose. He didn't meet the burden of proof.
yes, that's right.
but the whole point of the preliminary issues was to avoid evidence.
Well, I would agree with that, my lord, but
I mean, it may be that the third preliminary issue was not terribly well chosen, but it was, and it is open to a court presented with this kind of question of interpretation to say, well, we can't answer it at the moment.
my lord, if that's the backstop position, we would be content with that, because the one thing we don't want is a ruling, if we happen to lose on preliminary issue 1, that somehow that has the effect of wiping out the effectiveness of the ABC liability exclusion, particularly given that this is a mixed bag of matters that would seem to even fall into the new interpretations, I put it. So that's fine. That would be our backstop position at the very least. But the fundamental starting point is, having chosen to frame this preliminary issue in this fashion, having urged the judge to make the order, and he did in the face of opposition from my client, you live by the sword, die by the sword. If you chose not to actually produce evidence that allows you to demonstrate that on their construction it doesn't exclude any of the allegations made, then that's bluntly their fault, and they have failed.
It's a slightly different question, which is that the terms of the third preliminary issue include the words all or any of, which seems to involve the court embarking on the exercise of considering them seriatim one by one.
Yeah.
And not applying a blanket all or nothing approach, either way.
My lord, I would agree with that, but even on the basis of dealing with them one by one, there is no evidence to permit the court to even intelligibly approach that question.
Well, maybe, I'm not sure about that.
In the face of the fact that my client on the confidential defence has denied all of this. So it's all at issue. My lord, those were essentially the short points I had on this issue.
I mean, you might, yeah, all right. I mean, it might be possible, for instance, to say that the allegation made in paragraph 7.1 was excluded, even on the appellant's construction of the policy. Likewise, 7.5, and we can't answer the rest. I mean, that's possible.
That is a possibility. I mean, that's essentially doing a quick summary judgment type approach, to pick up my lord's point earlier. The difficulty being, of course, there just is no evidence to due support this. And my client can't call any evidence at the moment.
No. Well, I mean, if we're going to embark on issue 3, we would have to assume that what's pleaded is true.
Yeah, I mean, why is it not in principle a question of having construed clause 5.215, we then compare that construction with the allegations in paragraph 7.1 and following. And we say, on our construction, they're either caught or they're not caught, one by one.
Yeah. So essentially, that it seems to me on that analysis, my lord, which I don't resolve from, there are 3 options on issue 3 if you're against me on the appeal. Either one can see that there are clearly paragraphs that fall within the new construction, and that's resolved, or on each of them taken in turn, the court is unable to express a view one way or the other, or the court expresses a view as to whether they're not excluded by the ABC. I would counsel against the third of those because that would require evidence. So it's really, can the court do anything on issue 3 at this stage? And the evidential point, or the burden of proof point I make is, no, you can't, with respect, my lords,
Can you
because
help me on this? What do you say the role of evidence is in this circumstance? I appreciate you say, well, there wasn't any, and if appellants wanted this issue decided in their favour, so I've got that point. But what's the role of evidence here?
well, so again, it's slightly difficult without articulating what's actually written here. But if one is to look at, for example,
Evidence would go to the truth or otherwise of the allegations.
exactly.
But why does one need to decide the truth or otherwise of the allegations?
Because the way the allegations are put, and certainly if one had to look at the earlier part of the confidential schedule, there are multifarious matters of fact, some of which might or might not be caught by the exclusion. And the only
What? But why? Because even on the appellant's construction, it's liability for actual or alleged.
Yeah.
So you take the allegations and you see, is that within the scope or not?
Yeah. The allegations made are matters of fraud. They're quite crucial allegations, in fact, to get right. If, I suspect, I was to seek to go for summary judgment on these allegations, given the nature of the allegations, it would be difficult.
That inevitably gets you into factual questions.
Yeah.
But why is this issue a factual issue? That's the point I'm struggling with.
I see. So if one took 7.5, now there are two elements there, the alleged wrong and the question of the nature of the wrong, which have fault-based elements to them. It would be, and if the question is 7.5 describing an actual or alleged, a liability for actual or alleged breach of these duties? If one's dealing with, for example, is it actual? Well, that's a question of fact. Is it alleged? Well, we don't know what's been alleged because that's set out earlier.
It's alleged here, isn't it?
The target company the claimant is alleging essentially against itself that there has been these breaches of duty.
There's quite a lot of argument to be had in this point. I just wonder whether we can really de novo determine the point.
The short point is
on this appeal, and whether it shouldn't go back to a judge to determine.
If that was the conclusion of the court, my client would be content with that.
Well,
because
the judge said the issue didn't arise, so he hasn't answered
Yep.
it. Although the appellant's notice does suggest that they want an answer to the clause, it's not actually a ground of appeal.
Essentially,
And it's not addressed in the appellant's skeleton argument. So it's you who brought this before the court in your respondent's notice. But you say we shouldn't answer it anyway.
the first point is, the primary point is what my client wants to avoid is if my lords are against me on the construction of issue 1.
Yeah.
My lords then naturally flow into issue 3 and determine that. And we say that that is not capable of being determined.
Right. So we don't disturb we may disturb the judge's order in that event by saying we can't answer it or decline to answer it. But that will then leave it open to some other means of resolving the question whether there needs to be a full-blown trial of everything that's alleged or whether some of it can, by some procedural means, be short-circuited.
So that's my starting point. And my secondary point is the reason why my lords find yourself in that position, and indeed
Yeah,
the reason
I follow that.
it is the burden of proof point.
Yeah, yeah.
But if you're not with me on that, then definitely issue 3 shouldn't be determined.
Thank you.
Those are my points, and thank you.
Mr. Sanzido.
Lords, just a small number of points to tidy up in reply. Right at the start of his submissions, my learned friend used the word harmoniously in connection with the way in which the contract should be interpreted, and I adopt that. It's a good word. It sort of adds to coherence. Coherent and harmonious would be ideal. So we are in harmony with each other on that. Oh, I'm sorry, I've been reminded that I'm no longer at the microphone. So I made the point that I adopted the word harmonious. The next point is that my Lord Justice Lewison asked whether leakage was a covered warranty, and the answer is no. That warranty about leakage is not one of the ones that are covered under the policy. The argument that the fact that leakage is a complex matter shows us something about the labels being unimportant in my submission is a bad point, because leakage is, as my learned friend acknowledged, a well-known concept, and there's no suggestion that what was excluded was anything different from the concept of leakage as understood.
If it's not a covered matter, why does it need to be excluded?
Well, that is the way exclusions work, is that just in case something under some other warranty might arise from leakage, insurers will be able to say that bit of the loss we're not covering. That's the way warranty.
That tends to suggest that coverage and exclusions operate independently.
Yes.
In which case, why is there a necessary contradiction between the two?
Well, this is the difference between logic and reading ordinary English, if I may very respectfully say so to my lord. It is not a logical contradiction to say A and, well, no, it is. I mean, to say A and not B. But my learned friend makes the point that you're not saying A and not B because A is the coverage of the peril, and B is the non-coverage of the loss, the exclusion of the loss.
Your logical proposition is A and not A, not A and not B.
I'm so sorry, my lord, you're right. But it is, so my learned friend says, well, there's a conceptual difference because the cover is of all loss resulting from the perils, and the exclusion is of all loss, well, resulting from something else. Where you do, and logically those are two different concepts. But if in fact what you end up saying is I'm excluding all loss that arises from the very perils I've covered, then it doesn't help you to say, well, it's only loss I'm excluding, not the peril, because then you are in fact excluding A, having previously said you're covering A. And that's why exclusions are independent, because you exclude certain types of loss, or sometimes you exclude loss with certain causes. But you never exclude loss that has one of the covered causes. That's what you don't do, because that is a contradiction. So you don't define it that way. I accept that exclusions can cut right across all the forms of all the various covered perils. That's how they work. They can do. But what they don't do is identify particular perils and bring them to naught, because that is a contradiction. So the leakage point, it was obviously on a different point. It was on the label point. And the fact there's a complex definition does not actually affect my point. There was debate about the fact that other exclusions refer to liabilities, and two were mentioned. My learned friend referred to secondary tax liabilities, and of course that is defined in terms of liabilities. That is liabilities. Not quite sure what his point was, other than they were broad. My lord referred to dilapidation liabilities and said, oh, that doesn't mention liabilities, and my learned friend adopted that. But if we look at the definition of the dilapidation liability in bundle B, tab 2, page 193, it's a defect, shortfall or deficiency in the provision for dilapidations under a lease. So what that means is there is a liability for dilapidations and the provision is not sufficient. And so the potential form of loss which is being excluded is for having an insufficient provision for a given liability, for a dilapidation liability. So although the definition doesn't use the word liability, a business person fully understands what's meant by it. It means a dilapidation liability that's not provided for. So it is, in ordinary language, part of a liability. So in my submission, that's not a counterexample to the meaningfulness of the labels. my learned friend at one point submitted that to be a liability, something has to be declared by a court or arbitration award, and of course that is not the meaning of liability. Know that I need to develop that. My learned friend, we were talking about the point about records, and I interrupted to make the point that it seemed to us that the records may come in because they are potentially part of a defence under the statute. And my Lord Justice Arnold, I think, put to my learned friend that doesn't that show there's a difference between the exclusion and the warranty? But no, it's actually a bit like the dilapidation point in a way. It shows that the warranty about records comes into play where there's been an alleged breach. It's not, although formally it's independent, the only reason it will ever cause loss is because if there is an alleged breach, keeping good records may turn out to be a defence to it. So, of course, the two are conceptually independent, but it is, in practice, for the relevance to the buyer and the seller, they're actually very closely linked.
So, on your interpretation, is this right? An allegation of corruption is made against the target company. The target company relies on the defence of adequate records and is acquitted, so no liability is established, but nevertheless the share value is damaged by the publicity surrounding the Crown Court trial or whatever it was. You are entitled to claim on the policy for that loss.
If we can identify a breach of warranty, yes. So in that scenario, the records warranty is not breached. We would have to identify effectively, probably, that the sellers knew that there was this allegation out there and didn't disclose it. But if that's the position, then yes, then that's the kind of thing that would be covered on my construction.
Sorry, but on my Lord's hypothesis, no liability was established. So why is there a claim then?
No, because on
your construction, it's excluded, isn't it?
No, on my construction, what's excluded is losses arising from the liability. It's my learned friend who says you can exclude anything arising from any alleged breach.
Because there would be a breach of the warranty, but not a liability arising out of ABC.
Yes, exactly. Yeah. So it's a good example of what is covered on my construction and what's excluded on my learned friend's construction. My learned friend said that on the question of certain loss, that since certain loss might be 99%, it's not really a good point on my part. But that misunderstands. So, the point I was making was not that certain loss means it could be anything up to 100%, because the loss is on a given claim. What it does mean is that some losses that arise from a covered obligation may be excluded. And in the case of any given claim, it may be 100%, or it may not be. And that depends on the nature of the exclusion as against the claim. Mr. Justice Foxton, my learned friend, said that the exclusion is a special clause meeting the test set out by him. I responded to that in my opening submissions by saying that the meaning, the marking of covered is equally special, and my learned friend did not respond to what I'd said about that. My learned friend said that even if you do rewrite, as we suggest, by changing or to for, there's still a contradiction because the exclusion still excludes some of clause 13.5. But that argument seems to completely fail to understand the point about what a contradiction is. And in a way, it's a point that I've just made sort of in response to my Lord Justice Arnold, that it's not a contradiction merely because an exclusion may exclude some of the loss that arises from a covered obligation. It's only a contradiction if the exclusion expresses itself in terms that mean that that covered obligation is not in reality covered at all. That's when you get the contradiction. So we accept that the exclusion is going to bite on some claims that might arise under any of the warranties, and in particular under warranty 13.5. But my learned friend was not able to identify any individual warranty which is contradicted by our construction. So that is an important point on the way these concepts work. My lords, then on the respondents' notice, we have never understood why my learned friend says that evidence was required to determine the question of sort of construction, if you like, of our allegations as to whether they do or don't fall within the the exclusion as construed by the court.
What are you inviting us to do?
Well, my
on
lord,
this C3?
I invite you to dismiss the respondent's notice and just say that this is not something that can be dealt with at this stage.
Well, that seems to be Mr. Quiney's at least fallback position.
Especially his fallback position, yes. And so the fallback position is the same as my primary position.
Right.
But I would certainly invite your lordships not to accept the invitation to now go through the paragraphs of the confidential schedule and express views
I
without...
think that's what we'd have to do in order to even begin to look at that
Well, yes,
issue 3.
But I'm inviting you not to do that,
Yeah.
because if you were to do that now, then we haven't had the opportunity at this stage of the day
No, quite.
to make full argument about it. There's nothing from the judge. And essentially, if my learned friend really believes there's a point that matters to the conduct, to the future conduct of this case, he can, of course, apply for summary judgment on the basis that our
I think we
allegation...
probably have to go into the anti-corruption legislation a bit in order to see what is and isn't an offence or so forth.
What matters is whether we've alleged anything that arises from a liability.
Yeah.
That's what would matter if I'm right.
Yeah.
And
But to be clear, the consequence of this would be tantamount to discharging the order for the third preliminary issue. Because in effect, your primary position and Mr. Quiney's fallback position amount to be saying you can't do this as a preliminary issue.
well, I'm not quite going that far. I am not resiling from saying that the judge could have done it. What I am saying is that this court, we don't have time to now go through it all in detail. We are on live stream, so we would have to take other steps. This court is not in a position to do it.
To be sure, but then that would suggest a remittal,
Yes,
so
but
that preliminary issue 3 be dealt with by the judge. But the reason why I'm asking the question is that really what you are saying? Are you really saying, I mean, I take your point, this court can't deal with it, but what you're saying that it should be remitted to the judge for him to deal with it? Or are you being a bit more realistic and saying, actually, in reality, this is not fit for preliminary issue?
well, mostly the latter, my lord. I'm just not conceding it was never fit for a preliminary issue. I'm just saying that where we've got to is that if I'm right on the main point, it will no longer be of great importance. And if my learned friend believes that he can knock out anything that matters before trial, he can have a go.
Yeah.
And so obviously if you were having preliminary issues, it did make sense to deal with all that at the time. Given where we've got to, it no longer makes sense. So I hope I'm making a slightly more pragmatic submission.
Shouldn't we just remit it to the judge on the basis that then he can determine with argument if necessary whether it should still be dealt with on a preliminary basis or whether it should be dealt with at trial?
Well, my lord, clearly, whatever this court decides, if the court dismisses the appeal, then that's the end of the action.
Yeah.
If the court
So-
is with me on the appeal, then there will have to be further directions.
Yeah.
I mean, it may be that your lordships would want to ensure that it was not somehow sort of a matter of res judicata that the third issue cannot be decided on a preliminary basis. But beyond that, I don't invite your lordships to go. If there's a further procedural hearing, then
Maybe the pragmatic solution, if you'll pardon the phrase, is for you to wait until you get a draft judgment on the appeal, and then perhaps see if you can agree what, if anything, to do about preliminary issue 3, or whether anything indeed needs to be done about preliminary issue 3.
certainly a possible solution, my lord. It might increase the amount of paper your lordships get in response to the draft judgment. But it's obviously a possible solution. But I invite your lordships.
But the point is that neither of you are inviting this court to reach a conclusion on preliminary issue 3. The only question is, should it go back to the judge, or should the order for that particular preliminary issue be discharged and leave it to the parties to
I have
will
no.
it by in some other way?
the only reason I'm making submissions about it, because I understood my learned friend was actually making a
Yes, I
submission.
mean,
that we
his
somehow lost
primary
on the burden
position
of
is
proof.
it should be decided. His fallback is to revisit.
Yeah, and so I am resisting the submission that we lost on the burden of proof by not putting forward evidence. That's the submission I resist, and assuming your lordships are with me on that, then your lordships, I've suggested that your lordships may well feel that at this stage it's no longer sensible to go back and have another preliminary issue on that point, and that whatever procedural steps are sensible are ones to be decided back in the Central London court about how to take it forward, having heard submissions after we've all absorbed your lordship's judgment.
Right.
My lords, that was all I wanted to say.
Well, thank you both very much for a very interesting day. Surprising to learn that we will reserve our judgment. You will get a draft in the usual way, which will come with an embargo, which means what it says, so it can only be shown to those on the distribution list. Now, that will be your opportunity to correct our English, but not our reasoning, and we would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal and any future conduct of the case, including the preliminary issues. If you can't agree, then please make short submissions in writing and we will make the form of order that we consider to be appropriate. The future hand down of the judgment will be done remotely by email to those on the distribution list and by release to the National Archives, so there will be no need for further attendance. Thank you both very much.